Good morning, everybody. Another edition of SME Business TV. Frankie Goodman, myself, Nigel Whittaker, here today. We're with Sarah Wilkinson from Thackray Williams. Good morning, Sarah.
Morning, Nigel. Very nice to be here and for you to have me. Thank you very much.
Oh, you're welcome. And we're going to be doing some regular interviews with different solicitors from Thackray's in different areas of law. Sarah, your employment law.
I am indeed. The ever-changing area of employment law.
Yeah. Tell us what's been happening. So I'm guessing it's been very busy for you, keeping up with everything. And I don't know, have you been having lots of inquiries from your clients as well?
Absolutely. So I think it was probably about 2 weeks ago now that the new phrase of furlough leave was introduced to the country. It's an American term. That none of us had really ever heard of before, and now everybody is talking about, are you being furloughed? Can I be furloughed? What does it mean to be furloughed? So that's probably the main source of our inquiries at the moment.
Yeah. When it first came out, I was trying to spell it with Siri, and Siri didn't know the word either. So I think it's a pretty new word to most people.
Absolutely. Hopefully she's caught up.
Yeah, I don't know. I haven't checked again. I know how to spell it now. It's one of the most used words this week, isn't it? So what's the news? How do you understand it?
So now, obviously, furlough is an American term, as I said. It basically means taking a leave of absence. And I think they probably use that because we've already got various other terms in English law which allow us to take a leave of absence from work for a variety of other reasons. It's been put in place to try and prevent employers from laying off or making redundant their current workforce, and to try and save some of their employees, employment really. It's actually, in my opinion, an amazing scheme that's been put in place very, very quickly, paying up to 80% of an employee's annual salary for them whilst they're on leave, and reimbursing their employer for that 80%. Now, obviously, the employer, if they want to, can uplift it and pay the full 100%. They just won't be reimbursed for that additional 20% on top of the 80% reimbursement. I say 80%, but it's obviously
a lot of companies haven't been saying that, so they can pay up to the 100%.
Yes, a lot of people haven't been saying that. Why would they? But it's then capped at £2,500 gross per employee per month as a basic salary, plus any employer's national insurance contributions and also any auto-enrolment pension contributions on top of that. So for some people, 80% salary, sitting at home, not having to work, not being able to go out and spend in restaurants and in cinemas and in theatres or whatever else they like to do in their spare time, it's going to cover their outgoings, and it seems like a fairly nice way to live the next few months out. But there are certainly some people that are quite worried about it and what it might mean for them. Does it put them in more of a risky position returning to work? Is their employer going to need them once this furlough leave scheme is over? Because it is only a temporary scheme. It's in place at the moment for 3 months, and then it will be reviewed after the 31st of May.
Frankie, I know you've got some questions on this as to how it relates to directors of businesses.
Yeah, we do, but also we had a question this morning, which was, obviously the government have said that they're going to backdate this till the 1st of March. However, a number of most businesses will have had people working within that period of time. However, especially for a business like ourselves, a lot of our business went down a lot earlier than the lockdown date, because we run campaigns for the over sort of 60s and 70s demographic. So our campaigns went, quiet very early on because they were already self-isolating. So we weren't able to run campaigns, and the people who we run marketing for weren't able to go out and visit the leads that we generate. So we didn't get paid within that month. So we probably made a sort of net loss of about 50% of what was coming into the business. So we didn't make any money in that monthly period. We had a number of businesses who didn't pay their bills and said that they couldn't. So we had a lot of issues on that side of things. So that's something we've been bounding around at the moment. We didn't get paid in that month period. Yes, there may have been very small amounts of emails being sent and very minimal amounts of work being done. I'm sure a lot of businesses will be in the same boat. Does that mean because activity was taking place, we're not able to backdate until the 1st of March? Or because we were already affected and effectively we didn't make any money in that month, in fact, we made a loss, could we backdate that salary till the 1st to try and obviously help us, sustain our business and keep going once everything returns to normal?
So my understanding of this at the moment, and I should qualify that with my understanding, because at the moment we're still waiting for further guidance on the scheme, and also we're still not sure whether or not any legislation is actually going to come out to clarify these points. But my understanding at the moment is that it can be backdated to the 1st of March, but it can only be backdated to that point where employees just have not been providing any work for the company at all. So if you have, even though you were suffering a loss because businesses, the business hadn't seen so much work coming in, if you were still performing even minor tasks, then furlough leave wouldn't apply at that point. It's only if, I think there's going to be a very small number of businesses that are able to backdate it to the 1st of March because this wasn't an idea at that point. And so it's only really for businesses that have that have closed entirely and put all of their employees on unpaid leave or even paid leave from that date. But if you're doing anything at all, however minor, in my opinion, as things currently stand, it wouldn't apply to you.
Yeah, interesting. And I guess another point on that is, so a number of people have been marked into the furlough scheme, and there's been a bit of back and forth of whether I should even be trying to help businesses through this channel. I've registered as a volunteer for the NHS by taking voluntary phone calls from home. So if people are feeling isolated and lonely, they can call a hotline. It's diverted to my mobile and I'm able to have conversations with people.
Fantastic.
Well, you think that, but there's arguments whether that should be being done or not. And there are a number of roles out there that I would also like to get involved in that are slightly paid roles, whether it be going and helping out supermarkets, whether it go helping out some of the important key worker roles that are out there. Can somebody on furlough go and work either as self-employed, work as voluntary, or go and try and help some of these people that are suffering at the moment?
So the guidance says that whilst you're on furlough, you can't be doing any work which brings in an income for the employer that placed you on furlough. Now, in my opinion, that means it leaves you open to going and working on a self-employed basis and bringing in income for yourself during your period of furlough leave. Certainly, volunteer work is absolutely commended and encouraged. Training is also permitted, provided your employer is paying you the national minimum wage if furlough doesn't cover that national minimum wage for doing training. But there's nothing in the guidance that stops you from taking on additional roles, even if those roles bring in income for you, provided it's not income for the employer that has placed you on furlough.
It's very interesting, and that's the first take I've said that. But the way you said that sort of statement that's come out from the government there, that I interpret that the same way. So that's very interesting, and I think
it's not something that people have really picked up on or raised. Because the statement is very clear, you can't be bringing in the income for your employer. But that's not to say, in my opinion, that's not to say you can't go into Tesco, who have just put out a campaign for another however many thousand workers, and say, can I help?
Which actually makes a lot of sense, because obviously with the self-employed ruling, they are allowed to carry on working if they're getting the government grant. I think a lot of people then turn around and said, well, hang on a minute, and especially for directors of companies who may pay themselves a very small salary and top up with dividend, those people have turned around and said, well, I'll only potentially get £700 back from the government scheme through the PAYE ruling, through the job retention scheme, how am I supposed to live on that? Well, if they can top up by doing things on a self-employed basis, then all of a sudden it doesn't seem as bad as it first sounded.
The only thing that I would say is that the terms of your employment contract will continue to apply whilst on furlough leave. So all the existing terms continue to apply, except for those in relation to remuneration. And so if in your contract of employment you have a provision which says you can't work for anybody else whilst working for us, that's where there might be an issue.
Interesting. And from that perspective, obviously these are very different times to normal. And I understand a business probably isn't going to go and change every employee's contract to give sort of, lesser sort of strict sort of terms on there. But if somebody did want to turn around and go to their employer, is that something that could be done? If they did go and do that and they didn't get a full change in their contract, would a written communication from the company saying, yes, we're happy for you to go and do X, Y, and Z, whatever it may be in the interim?
So to be on furlough furlough leave in the first place, sorry, I'll put my teeth back in, you will need to have a written furlough agreement from your employer anyway. And usually that's going to include changes to the terms and conditions of your employment whilst you're on furlough leave. And it will be any changes for that limited period of being on furlough leave. And the changes that are going to be in place for the majority of that agreement are the changes to your salary and what it means to the changes to your salary. Now, if in that agreement, in your contract, it also has in there that you can't work for other employers whilst on furlough leave, and you say to your employer, look, I'd quite like to be able to do X, Y, and Z while I'm on furlough leave, would you have an issue with this? And if they don't, then it can be included my advice would be to include it in that furlough agreement, which will change your terms and conditions of employment with agreement, because you need to have agreement from both parties to do that, and just for a limited period of time. Whilst you're on furlough leave. So then when you go back after furlough leave to working, your terms and conditions of employment remain the same.
It's quite interesting because I think everyone's rushed into doing a lot of these processes already.
Yes.
And actually no one's actually considered the things that may change over the next few months, especially where we don't actually understand how long this is going to last and how long this is going to be in place for. So you're absolutely right, and I understand it's changing daily, and there are changes that are constantly being made around the sort of employment law at the moment. But it just seems that everybody seems to have rushed in, tried to put all these things in place because it's all you've got to make sure you're covered. And I understand that we was in the same boat and we had to make sure we survived this time. But it just seems like these sort of updates are so important. How do people gain that information as everything's evolving and changing so quickly?
So the advice, the main crux of the advice from the government came out last Thursday, I think it was, and a lot of people, like you say, had rushed into it and already put processes in place before that. My advice would be to just step back, take a breath, look at what it is you need to do, what it is you have done, and whether any changes need to be made to the things that have already been done, just to make sure you are still complying with employment laws. You have complied with the current guidance as it's currently set out, and then just to keep yourself educated on the guidance as it changes. I'm not expecting a huge amount of other changes to that guidance now. We're still waiting for guidance on how to calculate employers' NICs and the pension contributions, but that's all they're threatening to hit us with. So I'm hoping now we've got the real nitty gritty of what it means and what we need to be doing. So if you are one of those employers that might have rushed into it and done X, Y, and Z to try and get things moving before we even knew really what was happening, my advice is to take a step back and just assess what's happened, whether you need to do anything more, and just to take a bit of advice as well. I mean, we're running a free helpline for all businesses, just to give us a call. They don't have to be clients already. It's just a legal helpline for any legal questions you've got during this pandemic. it's free, completely free. So just give us a call, and we should hopefully be able to take that step back with you and assess what's happened and what you might need to do.
That's fantastic. And we can put the phone number below for people to be able to reach out to you as well.
That would be fantastic.
Brilliant. That's really good. And I think, there are a lot of people who watch these sort of communications, but have their own interpretation on things and their own slight differences. And as much as you can try and gain as much information as you can over the internet at the moment through the government websites, through, channels like this and through other means, everyone's situation is unique. And I think having someone they can reach out to is superb. But everyone can be a little bit concerned of, how much is it going to cost me? Can I talk to you without, being a client and so on? So the fact you're doing that is really good.
Yeah, there's going to be no clocks being turned on as soon as the phone rings.
Brilliant.
That was very concise, Sarah. Thank you very much. I was watching the Martin Lewis show, and he said he'd been talking to people up at the top of government. And the story was with this furlough was to be generous. The government want businesses to be generous, take on people even that they've recently laid off, put them back on employment, to furlough them. Would you agree with that? That's the side to err on, generosity.
That's a tricky one, because it's not just about generosity, and an employment tribunal looking at a situation where someone's been laid off or made redundant are going to look at the business reasons behind that decision. So Martin Lewis was encouraging people who had been laid off to go back and ask whether or not they can be brought back on. And I know that's because the advice from the government is that employers can rehire any employees that they have made redundant or laid off since the 28th of February. And it's the 28th of February because that's the deadline for employees who are entitled to furlough leave. And absolutely is the question. You can totally go back to your employer, if you're one of these employees, and ask, can you please rehire me and place me on furlough leave? I'm a very strong believer in, if you don't ask, you don't get. And so it's, in my opinion, it is always worth asking. And the worst case scenario is that they say, I'm afraid not. What they will do is, hopefully, if they're well advised, is consider what the decision was to make them redundant in the first place. If the business decision and the reason for their redundancy was completely unrelated to the current coronavirus crisis, and was for a completely unrelated business reason, a restructuring perhaps or something like that, then my advice to those employers would be to leave them, to stand firm by your decision, and leave it as it was. If, however, the business reason behind their redundancy was the fact that you suddenly know you're not going to need them whilst this pandemic is in process, then there's absolutely a reason to rehire them and place them on furlough leave. And if they're happy to agree to that slight reduction in their salary, it shouldn't really cause too much of a loss for you.
Again, it's very clear. Perhaps Weatherspoon should have a listen to that one.
Absolutely.
What would be the rule there, though, so that you rehire somebody, so effectively you're putting them back in an employment contract and they're working for your business again? Is there any uncertain ground of when everything returns to normal and the business just wants to, remove them from the business again? If somebody had handed in a notice before, what happens if they turn around after this and say, well, actually, I don't want to hand my notice in anymore?
If they'd handed their notice in, when would they have handed their notice in?
So if they left to go to, for example, to another job prior to, after the date that was mentioned, so the 28th of February, I believe. So if they've left to go to another job, but that company has now gone bust in what's happened, you've rehired them. And then once this is all over,
very generous employer to rehire them in that scenario.
Yeah. Would that be leaving them on some dodgy ground there?
Well, they'd still obviously it's still entitled to terminate their contract in accordance with its provisions at any time. Their contract is back in force as it was before. Their continuous service remains in place. So if they want to then resign at a later date, once all of this has has passed and they're offered another job elsewhere, then they are more than entitled to hand in notice in accordance with their contract. Similarly, because their continuous service remains the same, you will still be entitled as their employer to dismiss them fairly, provided you follow the unfair dismissal protection that they might be entitled to if they have more than 2 years service. And redundancy is always still an option for you. And so if there is no need for their continued help in the workplace, there isn't a need for them to carry on work of a particular kind, then redundancy is absolutely still an option, provided you follow the fair process and comply with usual employment laws.
Thank you. Do you know, I think we've got a lot of really clear advice for all the members of Pure B2B and other people watching SME Business TV this morning. Frankie, do you have any more questions, or do you think we've covered that actually?
No, I think we have. I think there's some real sort of questions that have been struggling to be answered there, and actually I think we brought a lot of clarity. So I think that's really good.
Great.
Yeah, thank you very much, Sarah. Thank you. We'll have you on again, I'm sure, before the end of all this is over. If you want to wind things up, Frankie, let's have a quick chat afterwards.
Sounds good.
Sarah, thank you for that. That was really good.